News Radio 710 KEEL is your news and weather station.
We are joined in studio by Attorney Jack Bailey to talk about the I would think legal ramifications of Friday's Supreme Court ruling as pertains to same-sex marriage, to gay marriage. Jack and I, good morning, by the way, a pleasure as always.
Hi, Bob.
We were talking yesterday. Well, let me back up. He sent me an email before we chatted yesterday, and I get an email from old friend Jack, and basically in referencing the Supreme Court decision, it says, Bob, this is much worse than I thought.
Jack doesn't talk like that, by the way.
Give him 5 minutes. Tell me why it's much. What did you think it was going to be on first hearing, and then when you spent your weekend reading the majority decision and the dissent, why is it much worse than you thought?
Well, Bob, I'm not here to argue the proposition one way or the other, and it's a great decision for the law business. My friends that do family law are going to love this
Divorce
case.
lawyers are
Divorce lawyer
in the streets.
And listen,
Therapists are happy. Yeah.
Everybody should have the right to have multiple miserable failed marriages and pay lots of attorney fees and new custody fights.
Who's got the smile?
I'm all for this law for all my brother and sister family lawyers, but here's the problem with the case. In history, all of the Supreme Court's cases on marriage have always been about some protected class, such as race, Loving v. Virginia. Now what they've done in this case, they've abrogated the 10th Amendment. Marriage and regulation of marriage had always been considered the province of the state, an individual state, and the state alone. There have been 36 national referendums in states over gay marriage. Only 2 state referendums, Maine and Maryland, passed. Now, in this case, what they've done is they've abrogated the 10th Amendment.
Which means rights reserved to the states, i.e., anything that the Constitution doesn't say the federal government can do, or can't do. If it doesn't specifically say the federal government can do it, they can't.
They set out 4 reasons why they were making gay marriage a new protected constitutional class. And one of those, and the principal one, and the only way they can make it a constitutional issue is, in their opinion, they say that the Due Process Clause and the Equal Protection Clause in and of themselves create substantive constitutional rights that are not enumerated anyplace else in the Constitution. And you want to recall, sex is only mentioned one time in the Constitution currently, and that's the 19th Amendment. The right of women to vote will not be abridged. And the ERA, which was no discrimination on sex, never was ratified.
So basically what the Supreme Court did, and correct me if I'm wrong and expound if I am, is that in their decision, the Supreme Court has leapfrogged, as I said, the legislative process, just bypassed the Congress altogether, and created by edict a new protected class.
This is social policy legislation. This is like Roe v. Wade.
But they're not legislators.
Well, they're not supposed to be, but that's what the modern U.S. Supreme Court has evolved into. They're black-robe legislatures, and with most of the Republicans, I won't say this about Scalia and Thomas, not that I'm big fans of theirs, but the rest of the Republicans on the court, you can book whatever the U.S. Chamber of Commerce wants, the U.S. Chamber of Commerce gets. And if in a case like this where the business community does not oppose it, who's going to do it? Roberts. If there's ever been a doubt that we don't live under a Supreme Court that isn't a corporate oligarchy member, you're wrong.
His word was Jack, a corporate tool. Well, never mind.
I've got to ask you this.
This is the most friendly, big business, international business Supreme Court in the history of the United States.
We have a ton of ministers, priests, etc., listening this morning, and they all want to know, what impact is this going to have on my church, and what kind of weddings I must perform?
Coexist.
Well, here are the 2 problems. If now being gay is considered as in the civil rights statutes as being a protected class under sex, you have multiple federal civil rights statutes: age, sex, race, religion, national origin. Well, one of the things is there is a conspiracy statute, and
whoa,
it's
whoa,
oh boy,
whoa, go ahead.
All right, it's Title 18, Section 241, Conspiracy Against Rights. And what it says, if two or more people conspire to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any right or privilege extended to him by the Constitution, it is a felony conspiracy, and it's one of the few conspiracy statutes in existence that does not require an overt act for the conspiracy to come into existence.
Catholic bishops get together and they talk about, guys, we're not going to perform gay weddings. They're conspiring against this now protected class.
If the courts end up saying that being gay is part of the protected classes, which that's what this case says, then all the civil rights statutes that set forth sex as a protected class become applicable, and there's an entire series of federal civil rights statutes, not just one or two. There are about 8 or 9 major federal civil rights statutes, and several of them contain criminal penalties. Not all civil rights statutes contain sex as a protected category, though.
Okay, our buddy Bishop Larry Brandon at Praise Temple, he has a gay couple come to get married at his church. He says, I'm sorry, we don't perform gay weddings. These folks come to you and say, Jack, we need to sue Praise Temple.
Well, first of all, they wouldn't be coming to me.
Well, let's say an attorney who handles those kind of cases.
They'd be going to the federal government probably, yeah?
Well, you might be filing a complaint with the EEOC to start the administrative process. I'm defending a business that I'm a member of right now because supposedly one of our managers did something against an employee because he was gay. The EEOC is already investigating and enforcing some of the acts that they are entitled to be the administrative agency on. The U.S. Attorney's Office already has a working group on these issues. We're going to find out in the courts. But what is bad about this, it's not just the gay marriage issue. It's the abrogation of the 10th Amendment. And if you got 5 people on the Supreme Court that now thinks for social policy reasons something should be done, we're going to have new constitutional rights, because what they've said is you don't have to have the right in the Constitution or be protected from the right in the Constitution. Out of the blue, the Due Process Clause and Equal Protection Clause in and of themselves create substantive constitutional rights. And if you read the reasoning of the Supreme Court, they do not identify anywhere in the Constitution where this right comes from. They're just saying,
we've created it.
We get, as social legislators, using due process and equal protection, when there are new understandings and society progresses, that we can discover new rights. This is a long opinion. I've read every single word of it. I've read both dissents. I wouldn't advise wasting your time reading Scalia's dissent.
Can the general public go read it? Is it available?
Yes, it's posted on the internet. Everybody can get it. If you're going to read a dissent, read Thomas's. He actually wrote a really good dissent.
Another segment or so with attorney Jack Bailey talking about the legal ramifications, church, religion versus and or attempting to coexist with the Supreme Court's gay marriage ruling on Friday.
Bishop Duca told us this morning, Jack, I hope it's okay if I call you Jack, said we may actually have to change what we teach in private schools, because in our religion classes we teach, about homosexuality is wrong, etc., and that's just the start of it. He said there's so much more we have to learn. Agree?
There's 2 problems here that he's going to have to confront and that we'll be confronting out at Evangel, and that's this. You have a nonprofit 501c3 that has an IRS exemption as a nonprofit. Now, if you take a position against what is now a fundamental constitutional right, are you going to lose your IRS tax exemption? Then second, you're going to have to find out through the court system, because there will be litigation on this, does this now implicate all the federal civil rights statutes and the criminal provisions contained in those civil rights statutes? Aaron, listen, everybody that knows me thinks that I'm a real extreme left-wing liberal. I'm a Democratic trial lawyer, but what a lot of us really are John Locke 18th century enlightened liberals, the classic conservative. This is a reach of federal power that was never envisioned not only by the founders, but you can read the text. The text says nothing about this. And so what has happened is, if now society changes, and here are the types of phrases that the court used.
I was just going to ask you, along with numerous notable legal scholars, think that they did some spaghetti-like moves to make this work.
Well, you're referring to Scalia probably, but you really ought to read Thomas's dissent. His is the substantive dissent. But look, here are these new tests that have suddenly come about for social legislation as fundamental constitutional rights. I wrote down the operative phrases. Changed understanding of marriage. New freedoms become apparent to new generations. Shift in public attitudes. Due process extends to personal choices. Let me repeat that.
Really?
Due process extends to personal choices. New insights now manifest. Intimate association, not freedom of association, refers to sex. This draws its meaning from related rights of procreation and education, recognition of the value of stability and predictability, and that current law is demeaning and disrespectful.
I had read, and I think it was in the majority decision, I believe I read so much on that this weekend, it said that people of faith will still be allowed to, and I think the quote was, advocate and teach their beliefs. And what I said to Bishop Duca was, but in the First Amendment, it says, exercise your religion. The Supreme Court seems to have left that word out. There's a gap there, yes?
Not only is there a gap there, but Thomas points that out multiple times in his dissent. And what he says is that the majority's opinion is an inversion of the original meaning of liberty, which is going to cause collateral damage to other aspects of our constitutional order that protect liberty. And what he's referring to there are religious rights. And it says, aside from undermining the political processes that protect our liberty, the majority's decision threatens the religious liberty of our nation. So right now I can tell you this, Justice Thomas, who I'm not one of his fans, but he is the most philosophically consistent justice on the Supreme Court. I don't agree with him most of the time, but that's what he's worried about, and he says it 4 or 5 times in his dissent.
Wrapping up, we've got about a minute or a minute and a half. In a nutshell, if that can be done, in the next 60, 90, 120 days, the next 6 months, is Denny up the street? Is Bishop Duca? Is Father Peter at St. John's? Are they going to be coerced into performing gay marriages? And if they don't, what will be the legal fallout? Will there be punitive
penalties? Yeah.
If the civil rights statutes apply, then there will be punitive actions, and there will be actions by the IRS. And here's what Thomas says about your question. It appears inevitable that the two will come into conflict, particularly as individuals and churches are confronted with demands to participate in and endorse civil marriages between same-sex couples. Religious freedom is about freedom of action in matters of religion generally, and the scope of that liberty is directly correlated to the civil restraints placed upon religious practice. The majority's opinion short-circuits that process with potential ruinous consequences for civil liberty. So Justice Thomas knows this a lot better than I do, sitting on the Supreme Court. I'm not a fan of his, but look, this is the Supreme Court justice that writes the substantive dissent in this case. He obviously sees exactly. The majority opinion, as far as I can tell, does not address this issue, and it is what Thomas is obviously worried about. And can we sort of suppose that if you're on the U.S. Supreme Court, you kind of know how the other guys think a lot better than I do?
You bet.
If you're a minister, if you are a Catholic priest, if you are in the fundamentalist realm, would it be safe to say that in the next year or so, your life's going to get, at best, confusing, possibly worse before it gets better?
Well, you just hope you're not the target of the test cases. And you also have to hope that the U.S. Attorney General doesn't start indicting people under the conspiracy statute. I think that's a little radical for right now, but when I was in law school, if somebody had said that there was going to be a substantive constitutional right to gay marriage, we would all laugh them out of the courtroom. So it's not too far-fetched. It may take many years, but I promise you, I know that these types of challenges are coming. I also know from privileged information, but there are pastors, priests in this city that are already extremely worried about this, and they don't know what they're facing. And an assurance that, oh, everything's going to be okay. Well, we know that the law doesn't always work out that way. And when you divorce law and from the democratic process, not only do you have problems like this, but you ruin the legitimacy of the court, because now they're sitting as super legislators making social policy. Whether you're for or against Roe v. Wade, look at what's going on. That decision was 1973, and because they short-circuited the political process, which they later did in cases like Bush v. Gore, Citizens United, what happens is the Supreme Court is damaging its legitimacy. And Roberts is not calling them as he sees them, like he said in his confirmation testimony. And so what we now know is you have a court in which the majority is oriented in making its decisions based on what is better for big and international business, not individuals and small business. So yeah, I think I'm worried about this, and I've got a relationship with some pastors that they've already consulted me. They're worried about this, and when they talk to me, I can't say, don't worry about this, everything is going to be fine, because I think Thomas knows a lot more about what's up than I do, so his dissent is troubling if you're a lawyer advising a religious entity.
Jack Bailey, thank you very much. We appreciate great stuff, man. Great stuff.